the multiple harms caused to women over 35 years now by the 8th Amendment, and to have this opportunity to discuss life and law under the 8th Amendment. It is a hard act to follow two of my great heroes, Catherine McGuinness and Catherine Ford, and of course, the great Pauline Conroy also. So thank you for your comments, and it certainly brought back to me a lot of my own experiences, what perhaps set me on the path to an illustrious criminal law career, having been facing the real prospect of going to prison. But there were some light moments in what was a pretty bleak time. And one of them, as Judge McGuinness memorably recalls, was the great student chants we used to have outside the forecourts. And while she used a particular word, I should say that we were slightly more respectable sometimes, and our chants went something like this: SP, SPU, SPUC, spock off. So that was a very memorable chant. Also seared in my memory from that time is the number of the clinic, in fact the number of the Underground Women's Information Network helpline that some of you will recall. You may recall that number, 6794700. Women have the right to know. Another great chant of that time. So it's interesting to recall all of that time. But certainly, and I want to welcome Minister Catherine Zappone here very much, and to say that it does feel like we have moved a long way, just coming today as Minister and myself, and indeed Catherine McGuinness and Catherine Ford have done, from a gathering of 30 or 40 TDs and senators today gathering to call for a yes vote on a cross-party basis. So times have moved on when we can see the big numbers of political supporters for a yes vote in this referendum on Friday. And I should say that although I was active and I am counted as one of the voices of the past, I am of course still somebody who was too young to vote in '83, as I keep reminding my own children who think I'm ancient. I never got the chance to vote, but all my adult life I've lived under the chill of the amendment, and I now have two small daughters growing up under the chill of the amendment. So I really hope, for their sake and the sake of their generation, that we repeal on Friday. So, moving forward from our case, highly memorable though it was, I should say that our case did rumble on for many years. We were declared bankrupt as a result. We did escape jail, of course, not escape from jail, which would have been a different story, although we were prepared for that. Mary Robinson actually told us the night before the court to pack our toothbrushes. So, I don't know how much use we'd have had for them in jail, but we were certainly all prepared to go. There was a last-minute change of judge, I should say. Judge Mella Carroll took the case and accepted the European law argument, as you heard from Catherine. That was a memorable time, and did rumble on. Of course, it was overtaken by events, notably the X case, as Catherine has said, the following referendum, the following amendments held in November '92, and then for a period of about 20 or 21 years, and that's my brief in 10 minutes before Mairead takes over, for the next period of 20 or 21 years, writing about this, I've said abortion really slipped off the political agenda for that period, albeit with some points where there were political focuses upon it. Catherine has mentioned the 1995 Regulation of Information Act, the appalling legislation still in place, circumscribing when we can give women information on where to access abortion abroad. We may well all have forgotten, or we may recall some of the cases which did come before the courts from time to time. The 1997 A&B case involving a 13-year-old girl who'd been raped and become pregnant. Again, the High Court found her to be suicidal and therefore entitled to abortion under the X case test. We might recall in 2007 the D case involving a 17-year-old girl with an anencephalic pregnancy who needed state permission to travel as she was in care, to travel for termination. We may also recall what I often call the forgotten referendum of 2002, and I know there are some people who still recall that experience. And that was an interesting one because in the late 90s, it seemed there was a bit of momentum for reform. There was a Constitution Review Group in '96, an expert group which recommended legislation be enacted to clarify the application of the X case. In 1999, a very progressive government green paper on abortion recommending a range of options, including the option of legalisation, but then followed by a deeply cowardly all-party Oireachtas Committee on the Constitution report, which suggested the government might seek to rule out suicide risk as a ground of risk to life. And that's what the government decided to do then in March 2002, putting a further referendum to the people, mirroring the referendum, the failed referendum, the 12th Amendment referendum of November 92, seeking to rule out suicide risk. The people defeated that. That was a bitter campaign. We defeated that simply holding a line on the X case. So it was not any gain for the pro-choice movement, but it certainly stopped things getting much worse for women. After 2002, abortion did slip genuinely off the agenda, but it was during that period that campaigners began to look to the international courts and the European courts for a different way of challenging our deeply restrictive and, as Catherine said, draconian law on abortion. And it's instructive to look at what happened next. Because we saw, I should say, some use first of the European Court of Human Rights, and of course the first case there was called the D case around the time of the 2002 referendum, and the D case involved a woman with a fatal fetal abnormality who had to travel to England, who claimed having to travel had breached her human rights under the European Convention. She failed to reach the minimum threshold on the basis that she could have taken her case before the Irish courts. And the European Court of Human Rights said there was a prospect she might have succeeded there. So the application was inadmissible. She hadn't exhausted domestic remedies. This was followed, however, by the substantive decision of the European Court of Human Rights in the more significant case for our law of A, B and C against Ireland, in which in December 2010 the European Court ruled that Ireland had breached a woman's convention rights in one of the cases. There were 3 applicants, A, B and C, but it was one applicant who succeeded, applicant C. And she was a woman who had travelled in circumstances where she had been advised that her pregnancy might pose a risk to her life. And it was in those circumstances where there was a lack of clarity as to whether she could access legal abortion in Ireland, in circumstances where the X case test suggested she should have been able to, that she was able to successfully claim her right of privacy, indeed, had been violated by the Irish state. And it was the ABC case that provided the legal momentum behind the decision of the government that came into office in 2011